She is sponsored by Representative Vernetta Alston, and we have Riley Land, stand up and wave, represented by Hugh Blackwell. It looks like we have another one. No? No, okay. That's all our pages. We hope you learned something. We appreciate you being here today. As always, we appreciate Lisa Brown being our clerk. And we have great staff here that we will call on periodically to read things, to make sure that we are good. We are not going to go in order on the calendar, because I think some bills are going to be a little easier than others. We're going to start with House Bill 275, failure to yield to blind pedestrians, and there is a PCS, and without objection, the PCS is before us. All right. Ms. Cairns, you are recognized to present your bill.
Thank you, Madam Chair. Good afternoon. Members, these two provisions in this bill are about people being seriously injured due to a vehicle driver failing to yield, and about ensuring that the persons responsible are not able to simply pay a small fine and never really answer for their actions in court. The changes in Section 1 are intended to add clarity, just to state specifically that someone who fails to yield the right of way to a blind or partially blind pedestrian is guilty of a Class 2 misdemeanor. The change in Section 2 increases the penalty from an infraction to a Class 2 misdemeanor for failing to yield and causing serious bodily injury. The current statute provides for a minimum fine and license suspension, but it is an infraction rather than a misdemeanor. Overall, the bill is about establishing liability when there is an injury and giving the court the ability to order restitution to the injured victim and the ability to collect restitution that can be converted to civil judgment and enforced as such. That's not currently available for infractions. I would appreciate your support for a favorable report. Thank you.
Thank you, Madam Bill Sponsor. And I'm just going to ask staff real quickly. Let's see, that is Susan. What was the change with the PCS?
The PCS adds Section 2 of the bill.
All right, thank you. And I will tell you, members, if you were on my committee before, we had sort of brought this up at one point, and we thought the law was clear. So it turns out it's not totally clear, so we wanted to make it clear that it is a misdemeanor, not an infraction. Further comments, discussion. Representative Butler.
For a motion at the appropriate time.
All right, we may be at the appropriate time. Any other questions or concerns? Representative Butler is recognized for a motion.
I move for a favorable report to the PCS for House Bill 275, unfavorable as to the original, with a referral to Rules, Calendar, and Operation of the House.
You've heard the motion. All those in favor will say aye. All those opposed, no. The ayes have it, and the bill will be so reported. Thank you. Next, Representative Miller, Representative Pirtle, are you going to be handling House Bill 330? Representative Pirtle, you're recognized to present House Bill 330. Oh, I'm sorry, I didn't know you were here. Representative Honeycutt is recognized to present the bill.
Yeah, thank you, Madam Chair, members of the committee. I think we have a technical correction amendment that Representative Miller is going to run if we want to do that first.
We can. Representative Miller, you're recognized to send forth your amendment. Do all the members have copies? We're not doing copies. You should have it online. We're online now. I will read. Okay. She's making it public right now, but I will read it to you. It just adds the bill by rewriting an extra line to call parafluorobutyryl fentanyl to the list of substances that are already there.
Yes, ma'am. Madam Chair, it's just a technical correction with a misspelling.
All right. On the amendment, any questions or concerns? Any other comments from the committee? Representative Miller moves that we adopt the amendment. All those in favor say aye. Opposed, no. The ayes have it, and it will be so reported. Now we're back on to the bill as amended. You recognize Representative Honeycutt.
Thank you, Madam Chair, members of the committee. Controlled Substance Act. It is basically our yearly update where we add new substances to the act. It's pretty standard and pretty technical. I'd stand for any questions.
Once they change those formulas, just to get by with it. Any questions or comments from members of the committee? I didn't see anybody signed up to speak on it from the public. All right, seeing none, Recognize Representative Miller for a motion.
Move for a favorable report, refer to rules, calendar, and operations of the House. As amended
Rolled in.
to a new PCS.
Yes. Thank you. You've heard the eloquently stated motion. Anybody confused? I'll read it again. All those in favor will say aye. Opposed, no. The ayes have it. The bill will be so reported. Thank you. Next, we have House Bill 315, Gift Card Theft and Unlawful Business Entry. Representative Purtle, you are recognized to present your bill, and there's a PCS, and without objection, the PCS is before us.
Madam Chair,
Yes, ma'am.
could I ask a question of staff, just how we find some of these documents? I kind of struggle sometimes to find the PCS, so if I go to the bill itself, or should I go to the committee page? Yeah, go to the committee page, and then under documents, how is that identified? Is it the CVVS business I'm looking at, or?
Well, I can tell you this one says H315-CSSA-6 version 2.
Okay. Is there a magic way to, what am I looking for when I'm looking for these PCSs?
PCSs will always start after the bill number with CS,
CS.
and summaries will always start with SM.
Okay.
All right.
And amendments will always start with A.
Representative Green.
Just a question, could you repeat that, what you said about what started with SM?
See, I knew nobody knew.
We're gonna go back to training before.
Yeah, the documents will always start with the bill number, and then the code right after that, it will start with CS for a committee substitute, SM if it is a summary of a bill, or A if it is an amendment to the bill. So they're sorted by number of the bill, and then you're looking for the document. And if you're looking at the website right now, like for House 315, the summary you see after that in parenthetical, it tells you it is the summary for the committee substitute.
Thank you, ma'am.
Now, just to throw out my comments as chair, we're getting into this new system of trying to do things online. I like paper, so mine are always paper. Y'all wanted to go online. We're online. Now we've had our education. Representative Purtle, you're recognized to speak on House Bill 315. PCS, which is properly before.
Thank you, Madam Chair. I got my paper instead of my computer. This is the gift card theft and unlawful business entry. This kind of started as, and I really didn't realize it was exactly how severe the issue was, but talking to the Retail Merchants Association, we have a circumstances where folks are going into retail stores and stealing gift cards, getting the numbers off the gift cards, then taking them back to the store, and when somebody purchases the gift card, it automatically activates. These folks that have done committed the offense are notified, and they're able to use the money that's on the gift card electronically before the person it was intended to. So herein lies what's before you today. Section 1 of the offense, Section 1 of the bill is the PCS that would amend the breaking and entering into a building generally to create a new offense of entering a portion of the building that is not open to the public with the intent to commit an unlawful act. I'd like to thank Representative Budd for her input in the language in creating that with intent to commit an unlawful act. I think it makes the piece of legislation much better. But an example of this may be going into a designated area of a building that is for employees only, where they count money or maintain some merchandise that is not otherwise should be open to the public. First offense is a Class 1 misdemeanor, and the second offense, it would be a Class I felony, second and subsequent offense. Part 2 of the bill would create or enact new offenses for larceny of the gift card if a person does any of the following: acquires or retains possession of a gift card or gift card redemption information without the consent of the card owner or the card insurer, obtain a gift card or gift card redemption information from a card holder or card insurer by means of false or fraudulent pretenses, or alters or tampers a gift card packaging in order to defraud another. Larcenies will be a Class I misdemeanor if the value of the card is less than $1,000, and a Class H if it's more than $1,000. Class H felony if it's it's more. So a class 1 misdemeanor if it's less than 1,000, class H if it's a felony, if it's over 1,000. 3 and 4 would amend the statutes of the organized crime to as related to the gift card theft, conspiring with another person to acquire or retain possession of a gift card or gift card redemption information without the consent of the card holder, devising a scheme with one or more persons to obtain a gift card or gift card redemption information from a card holder, and conspiring with another person to alter or tamper with the gift card. Of course, the punishment depends on the aggregate amount of the fine or the larceny itself, and it ranges from an H to a C felony depending on the aggregate value of the card. And 5 is that was part of the PCS also. That just put the language in there for the civil liability for the larceny and similar offenses. And I'll stand for any questions.
And I believe the PCS was some of the suggestions by Representative Bud.
Yes.
Tweaking some of the language. Okay.
Yes.
Want to be clear. We were all clear on what we're dealing with. All right. We are now open for comment or discussion from the committee. Any comment? Any discussion? See how easy my people are? Wow. We got 2 more bills. Representative Bud.
Let me not destroy the kumbaya moment there. No. I did want to say that I learned a lot when working with Representative Pirtle and some of the other folks with respect to this bill with the gift card theft. I had no idea how much gift card theft was because I was naive and I was like, what do you want to do? You want to make this a felony for stealing a Starbucks gift card for $100? Only to find out that people are stealing them by the hundreds and then taking the numbers and spending the money themselves. So for that, thank you for the education piece.
And I'll recognize you for a motion. Representative Green can give me one if you want.
Well, I'll be glad to do that. I just did have one question, because I recognize it's got to be a significant problem with gift cards and how easily they can be done. I'm just wondering if the sponsor or anybody from the Retail Merchants Association has an estimate of how much value our merchants are losing on this kind of thing each year.
Mr. Choir Director, do you have an answer? If you can go up and put it, let's get you on the record with your name and everything.
Just curious.
That's fine.
Thank you, Representative Green, for the question, Madam Chairwoman. I don't have an overall number.
And you are?
I'm sorry, I'm Andy Ellen with the North Carolina Retail Merchants Association. I don't have an overall number for you. I will tell you that they just arrested a ring last week in New York, and they had found $20 million worth of gift cards that they had stolen there just in that one occasion in New York, and those were Lowe's and Home Depot's cards, if I remember correctly. But we'll try and get you an aggregate number before the bill moves into the Rules Committee. Thank you.
Thank you. Now, Representative Green. Anybody else got questions or comments?
I stole your motion from you. Yeah.
Go ahead.
Madam Chairman, I'd like to make a motion favorable to the PCS on, and I bet you would have had the number.
House Bill 315.
House Bill 315, unfavorable to the original, with a referral to Rules.
Good job. Having heard the motion, all those in favor say aye.
Aye.
Opposed, no. The ayes have it, and it will be so reported. Next, we've got the other 2 bills, which are a little tougher, and I'm going to ask Representative Green if he will come up and conduct the committee so we can get our proper sponsor before us.
All right, so next we're going to do House Bill 308, which I understand we have a PCS before us, and without objection, we'll consider it properly before us.
All right.
All right.
You want to recognize me?
I'll recognize Representative Stevens.
Thank you. Thank you. Okay, this is some criminal law changes. Most of them are at the request of the Conference of District Attorneys. Section 2 defines strangulation as impeding the normal breathing of another, and to make it clear that it's not just an actual damage that has to take place, but it is a serious injury as well as just under the threat. My notes might make it easier. It impeding the normal breathing or applying pressure to neck or throat, obstructing the nose or mouth of a person during an assault. Currently, strangulation is only a crime if there's physical injury. This this bill makes it a Class H felony, and if it causes physical injury, then it is a G. The bill also increases punishment from an F to an E if you commit an assault that results in serious bodily injury as defined in the statute. Section 2 is the misdemeanor domestic violence crime. It was created in 2023 by S. Bill 20, but failed to address certain issues that they're having with these new domestic violence statutes. It clarifies the misdemeanor crime of domestic violence is not a lesser included offense of misdemeanor assault. It adds a new form of assault to the habitual misdemeanor assault statute to prevent repeat offenders of domestic violence. It authorizes police officers to arrest for this misdemeanor when it does not occur in their presence, like the other statutes of domestic violence. It's making them consistent. It also adds to the statute a list of crimes that for which the judge must see a judge to set bail and determination conditions of release. They're all in essence related to domestic violence nature crimes. In expunctions under Section 3, it takes the same language passed in 2023 by House Bill 193 related to expunctions of certain offenses, certain misdemeanors and felonies, prohibiting people with new or pending charges in this state, another state, or the federal jurisdiction from getting an expunction. It clarifies that all petition-based expunctions, any active criminal process or prosecution of the petitioner prevents an expunction. Section 4, currently, if a judge issues a sentence on multiple offenses in court and doesn't specify the sentences are to run concurrently, this sort of flips the lid and says, Judge, if you're sentencing them on each of these offenses and you haven't bothered to consolidate them, people anticipate that they're going to get this many judgments, this much time. So we flipped it to say the judge can say concurrent or consecutive. If he doesn't, they are consecutive. And then I've got some more information about the law on strangulation and the reason we did it, some of the case law that was there. So I'd ask for your support.
All right, thank you, Representative Stevens. Any members of the committee have any questions? Representative Butler.
Madam Chair, did we get an incarceration note on this bill? I have concerns that specifically the move to make this sentencing consecutive is going to create additional terms of incarceration, and I don't think we've seen.
I'm going to, with the chair's permission, I'm going to see if staff thinks we need one.
Representative Butler, an incarceration note has been requested. Fiscal let me know this morning that it would not be available for today yet, but they are working on it. So pursuant to the statute, it will be available before it's considered on the floor. So they're still working on it.
Okay, follow up, I guess, Mr. Chairman.
Follow up.
Yeah, I mean, I think that would have been important to have for this hearing, because obviously if sentences are now going to default to consecutive sentencing, you know, it could vastly increase the terms of people's sentences and therefore the dollars associated with keeping those persons in jail. So I think it's incredibly important that from now moving forward that we do that in a timely manner, because it's hard to evaluate the bill otherwise. Just curious why we're doing that. I know that we have a lot of judges on the bench who may or may not be aware of these changes, and they're going to assume that if they don't specify that those sentences are going to run concurrently. Can you explain what the motivation might have been for this?
Representative Stevens?
Thank you. As a person who works among this realm, I frequently have people complain to me that the judge has sentenced this person to this offense and this offense and this offense and this offense. And they don't realize that the judge, if he doesn't say anything, they all smoosh together. This is more about truth in sentencing. That if the judge is sentenced on multiple offenses, I see a lot of district attorneys nodding their heads, that people anticipate that that's what it is. So it's more of a truth in sentencing type feature.
All right. Additional, Representative Charles Smith.
Thank you, Mr. Chair. My question is related to the first section of the bill and the definition of strangulation. Really the second piece of that, from the language here, it looks like maybe there'd be two ways of alleging strangulation, the second being by obstructing the nose and mouth of the person. And I just, I have concerns about that language. I think it could be interpreted different ways. I don't even know that obstruction really necessarily even requires touch, potentially. And I think it's just important that when we're, changing these criminal definitions, it's really two-pronged. We want law enforcement to be able to know, criminal conduct and recognize criminal conduct. We also want people to know what kind of conduct is being prescribed. And so when you define strangulation as obstructing the nose and mouth of the person, I think that could require touch. I don't think it has to require touch. I don't really know what that means necessarily. I don't even mean that sarcastically. I think it can lend itself to different interpretations.
Representative Stevens, would you want to respond?
Well, I have 4 cases where it's been somewhat of a concern for the Court of Appeals too, and I'm happy to defer to Chuck Spahas if he's nodding his head, he wants to answer, so I'll let him explain.
Thank you. Chuck Spahas, General Counsel of the Conference of District Attorneys. Representative Smith, you actually pointed out exactly what we're trying to accomplish here is a definition that makes clear that if you attempt to prevent a person from breathing, then that's what this is about. So when you make the decision in an assault that you are going to restrict the airflow to the body, either by strangulation or otherwise obstructing the nose or the mouth of the person, that's the behavior we were after describing. When a person makes a decision to cease the airflow to a body, that's the kind of behavior we're saying warrants stepped up punishment.
All right. Yeah, Representative Stevens, did you have additional?
I think that's a great explanation. I just didn't know that satisfied.
Any additional questions? Yeah, Representative.
This may be a question for Mr. Spahas as well. As someone who does not practice regularly in criminal law, I just want to make sure that this includes, when we talk in subsection A2 with regards to applying pressure, that is not limited to someone's physical hands, but that could also be objects such as pillows or anything that would obstruct breathing, just to make sure this statute is clear, because I think this is important, especially considering the fact that strangulation is typically the step before death for a domestic violence victim. I want to make sure that's very clear, that we've covered any method of strangulation by any means.
Yes, ma'am. Again, Chuck Spahas, General Counsel of the Conference of District Attorneys. We do believe the way we've described it, and we looked at several states that have done this and tried to find a broad enough language to cover just exactly what you're saying. If you were to take my tie and grab it from behind and try to keep me from breathing, it would cover that. Or if you decided you were going to wait till I was asleep and you tried to smother me with a pillow, that it would cover that as well.
Any other questions or comments from members of the committee? If not, we have at least 2 people, I think, signed up to speak on this particular bill. You have 2 minutes each, and first we'll have Liz Barber. And if you would just give us your name for the record and your affiliation.
Sure. Good afternoon. I'm Liz Barber, ACLU of North Carolina. And I'm here to speak really on a very small portion of this bill, and that is about the default between consecutive and concurrent. For decades, I believe, I'm not sure how many, the default has been concurrent. And I think it's important for the vast majority of people who don't practice in criminal courts to understand when someone is sentenced for multiple sentences. I think most people's mind goes to someone who committed a bunch of different armed robberies, right? They went out, they robbed this person and this person and this person. Well, what we see a lot in criminal court is someone who went and sold drugs once. And so you'd think they'd be sentenced on one thing, because there's one sale. But instead, they're sentenced with possession of the drugs, with possession of drug paraphernalia, because they probably have scales or baggies or something to sell the drugs, with the actual sale, with maintaining a vehicle for the sale of drugs, or maintaining the vehicle for something. So it can be 4 or more crimes that are committed when most people would see that as one criminal act. And so while I appreciate the desire for us to have transparency in sentencing, there's not a whole lot lot of transparency in like criminal courts and sentencing with how it works, because it's really complicated. I mean, just looking at the felony sentencing grid, it's really complicated. I tried to explain it to someone just yesterday. So I think that my other concern is for judges who have been on the bench, some probably longer than my younger colleagues at the ACLU. They just have it in them that if they don't say anything, that it's going to default to concurrent. And so I'm afraid that unintentionally people are going to be getting consecutive sentences, not because the judge has decided that they want that person to get consecutive sentences, but because they're just silent. So one, I don't think we have a problem. I wish that we would just remove this section altogether. But if you do think that there's a need for a change, I would rather that the judge has to say consecutive or concurrent rather than having the option to remain silent. Thank you.
All right, thank you, Ms. Barber. And we have a Tara Callahan. Is that right? Am I pronouncing that right? And if you would state your name and affiliation for the record, please.
Hi, I'm Tara Callahan with Conservatives for Criminal Justice Reform. Just wanted to flag concerns with the same provision of 308, the Section 4 with consecutive, not concurrent. We certainly recognize the importance on truth in sentencing and just have some concerns about the impact on DAC. They've been understaffed and over capacity for a lot of years now, and this is going to have a huge impact on how long folks are serving sentences, and how long they're serving is certainly going to also impact the healthcare needs for the agency. So just wanted to ask if that is considered in this legislation. Thank you.
All right, thank you, ma'am. And I think Representative Budd, I'm advised, may have had a question before we move to public comment.
I did. I'm going back to the habitual domestic violence section. It had to do with defining a person who's committed the offense, 2 or more. I think that I love 2 or more. But how does this apply if you have someone who victimizes multiple women? Again, I don't practice in criminal law, but I have seen enough where you have an abuser who victimizes multiple women. Is there a way to expand this language such that if there's a pattern or practice, we can catch them under this?
All right, Representative Speos. I think Mr. Speos from the Conference of District Attorneys wants to address that.
Thank you, Mr. Chairman. Charles Spahos of the Conference of District Attorneys. This thing actually is based on conviction, so it's not predicated on it being the same victim. So if they were in one county and did it with, let's use a wife or a spouse, and then separated, went somewhere else, married or otherwise, and commits a new offense, as long as it results in a conviction, then it would be captured, and it does not require to be the same victim.
All right, thank you, Mr. Speos. Representative Butler.
Yeah, I just had a question, again, I guess, for you, Madam Chair. So, if you're a kid and you're out late night and you're checking door handles on cars and you take something from 2 different vehicles, let's say, I really do believe that most people would assume that that is one act. You've gone on a bit of a spree and you've taken a thing out of 2 cars in the same driveway even. But so now that person is potentially going to be charged for 2 crimes and serve consecutive sentences. I mean, is that correct?
Representative Stevens.
Thank you. It is possible, but as I was talking with several of the DAs, they're frequently, when they do their plea agreements, indicate that the sentences will be concurrent. And that is clearly stating to the public what will happen. The judges will go to school and learn this. That's part of their judicial annual updates, is they have to learn about the changes that are in the law. They need to say consecutive or concurrent. If not, it should be consecutive. That is truth in sentencing.
Okay, just a final thought, if I might, Mr. Chair.
You're recognized.
Okay, so, given the testimony we've heard earlier and the recognition that our prisons are overburdened and understaffed, what if we tabled this until next week so that we could get that incarceration note? We really need to understand the magnitude of this problem. I mean, we have violence in our prisons. They're overcrowded. Again, they're understaffed. And this could have a really magnifying effect I feel like we should understand that before we're asked to vote on it in committee. What about just tabling this until next week?
Representative Stevens, would you want to respond?
I just oppose the motion to table. It's still got away. You will have this report before next week when we go to the floor with it. If not, we'll hold it up on the floor. But it also still has to go through the Senate. So there's still a lot more time to weigh in on it. But I think we're here about the judicial part of it, and it is about some truth in sentencing.
I'll withdraw the motion.
Thank you. Any additional questions, comments from the committee, or do I have a motion? Representative Purtle.
Thank you, Mr. Chair. Make a motion favorable to the PCS, unfavorable to the original referral rules.
All right, we have a motion from Representative Purtle for a favorable report to the PCS, unfavorable to the original with a referral to rules. All in favor, say aye.
Aye.
All opposed, no. The ayes appear to have it. The ayes do have it, and it will be reported favorably. All right, now we'll move on to House Bill 237. And is this a PCS? We have a PCS on. All right, so we have a PCS to House Bill 237, and without objection, the PCS is properly before us. Representative Stevens, please.
Thank you. And I know this bill may take a while, and it's going to take some effort for a lot of people to help me weigh in on things, but it has a long journey. If you see, it goes next to health and then in favorable to rules. And this is some stuff we've been trying to do for a long time with the Department of Social Services. The first thing amends several child welfare laws, talking about when the dates and things should be, trying to get these children to more permanency quicker. It stays the Regional Abuse and Medical Specialist Program, RAMS, until it completes the rulemaking process and, if applicable, obtains federal approval. It creates a private cause of action against the Department of Health and Human Services if an individual is harmed by a program or policy administered, supervised, or funded by DHHS that did not go through rulemaking. DHHS needs to understand they must follow the rules that everybody else follows. It requires members of county boards of social services, regional boards of social services, and consolidated human services boards to attend education and training created by DHHS and their stakeholders, because we are that unique system that we are county administered and we are state supervised, but the state really can't come into supervision until there's a problem. So we're trying to get the counties to understand what a critical factor it is. In one version, it's not in this one, but in one version, I at least had counties to start being potentially liable along with the state for compensating for damages. I didn't realize that the state picked up all of the damages for any DSS case that gets screwed up. They're not state workers, they're county workers. So the county should have some skin in the game, but that's not in this bill. Require the AOC to conduct a feasibility and cost study to establish a child support tribunal. I know we have sort of done that before, having child support tribunals. It would establish a conflict of interest procedure for county departments of social services, regional departments of social services, and consolidated human services, and require that they adopt rules. We've had problems with conflict of interest in the past where, and I can pick on my own group, and they're here. Wilkes County Department of Social Services sent a child to another county, and the county says, we're not going to follow it because it's not a good and proper placement. Wilkes sent it anyway, and the children wound up getting even more hurt than they were with the people that they had put them with. So we have to get some kind of conflict of interest in place to know how we can resolve conflicts like that. We're going to require the Joint Legislative Oversight Committee on Health and Human Services to study and make recommendations regarding child welfare matters and DHHS compliance with rulemaking process and Administrative Procedures Act. Then it makes certain other clarifying and technical changes. And so I'm sure there's not but one or two questions, and it looks good, right? All right.
All right, thank you, Representative Stevens. And do we have questions or comments from the committee? Any discussion from the committee at this point? If not, we have.
We got two here who want to speak.
Okay. All right, Representative Butler, you're recognized.
Yeah, of course, this is a rehash of what we saw. I guess, last session. And there's a lot to be concerned with here, but one of the things that strikes me the strongest is the way we are not directly criminalizing, substance use disorder on the part of, mothers who are pregnant. But I fear that, again, taking this strong tact with them is going to lead to worse outcomes, for both mothers and babies. I have heard from a medical professional who works with the Reach Maternity Clinic, and I would just like to put his comment into the record. He is concerned that as a maternity care provider with a special interest in pregnant patients who struggle with addiction, that these two bills are of particular importance to him and his patients. Every week he runs a clinic for the patients called Reach Maternity Clinic. And I know, and he says, I know without a doubt that these bills will lead to worse outcomes for mothers and babies. I would like to offer my expertise anytime to the committee to discuss matters relevant to care of pregnant patients, addiction medicine, or healthcare policy. So the medical professionals are very concerned that we are going to deter mothers from seeking prenatal care because they suffer an addiction or substance use disorder. And so that is my biggest objection to the bill, honestly. And I didn't think it was good last session. I certainly don't think it is now. But I'll let others speak.
Representative Stevens.
Okay, let me just comment right back to you, and I appreciate that, I truly do. And it is my intention that if parents are mothers especially, are receiving care and trying to get past their addiction, then this is my intent for this not to apply. And I think I've got it in there somewhere that as long as they're working on this compliance with treatment, that shouldn't be an issue. But mothers who aren't getting treatment and are having children who are born substance addicted, those children need to be taken care of. So sometimes this is a balancing test between a child and a parent. The parent has some control, the child doesn't. So if the parents are receiving treatment, and if you think it's not fully dealt with in there, I'm happy to work with you on an amendment going forward, because I'd like them all in treatment. But if they're not in treatment, I'm concerned about the baby that comes.
Thank you. I think Representative Budd, did you have a question?
I did. I'm going to try to marry come work with me for an amendment with the significant concerns I have too, considering that addiction is a disease, and I don't believe that addicts actually have control. It's how we as a society, and in this case the General Assembly, the legislature, J2, is going to provide the means and mechanisms to help those parents get back on track. We specifically talk about mothers who are pregnant, but I'm also going to address fathers with my question here. And that is, had you considered adding in a provision that requires the court, if the parent is not in treatment, to make sure that treatment is offered and there are actual options available? Because oftentimes it is locating the resource to get the treatment, then it's accessing it, and if needed, paying for it, because we have such a scarcity of resources on that level. So I'd really like to see us bridge what you're trying to do with what Representative Butler's concerns are, to see if we can do that.
Representative Stevens.
And I'm happy to work with you on those kinds of things. In the interim, before we get there though, I'm concerned about a child whose parents are not in the process of getting treatment. And let me just reiterate one other point from you. If you have the money, if you are the grandparents or the aunts and uncles or somebody else, and you have the money, you come and hire me as an attorney, I get that child out of that environment in no time. And typically when that has happened, I find the parents don't come back around. So that is my concern. The people who do not have the money and the resources to protect their babies from addicted parents gives me concern. But yes, I'm willing to work with you moving forward to try to see that we get that done.
Follow up?
So just to make sure that I'm clear, you're willing to entertain an amendment following this hearing to mandate that the courts offer access to and that the state pay for treatment. And of course that assumes, again, the parent has to be willing to engage and participate. I don't want to put the cart before the horse. I'm looking at a resource availability. And then the second, if I may add, Representative Green, is the concern with criminalization for pregnant women who are suffering from addiction it again, it is a disease. It is not an option. We all know that no child gets up and says, I can't wait to be an addict when I grow up. I can't wait to be pregnant and have the state take my baby. No one says that. So I think criminalizing or even indirectly leading to the fear that it's criminalized behavior is a problem. And so I'd like to see us look at language that specifically states this is not a crime. This is purely a protective child measure. That's it.
Representative Stevens.
Thank you, and I don't believe there's anywhere in here that it mentions that it's a crime. It stays in the the abuse, neglect, dependency statute. So, you know, if you feel that's some kind of need to be clarified, but it's not criminal. The judges do have an obligation, even if they take the child right away, protect the child, they have an obligation to work with the parents toward reunification. They've got a year to do that. They do order these kinds of treatment, and then, that's one of the obligations they can do is say, wait a minute, they've tried, but they can't get treatment. But again, I still put the child as number one. While addiction may be a problem, it is a problem created by that human being, not by the little one that comes out that has no problem in the world.
Thank you. I think we do have some members from the public. Here to speak.
Oh, wait a minute, you had some down there that wanted to say with the committee.
Yeah. Representative Charles Smith.
Yeah, the other C. Smith. My question's related to part 3, the private cause of action. I understand this would only be available if the department or designee acts without going through, I guess, the required rulemaking process, so following their own rules. I mean, if that were to happen now, the individual harmed by the state agency could still take advantage of the state's Tort Claims Act. Is that not correct? How does this provision? What is its relationship to the state's Tort Claims Act? I think that if this were to occur, if the department acted or designee of the secretary acted in a way that did not abide by the department's own rules, I think the person would be able to pursue an individual would be able to pursue an action through the state's Tort Claims Act already.
Representative Stevens.
Thank you. They can, but sometimes these groups don't understand the difference between a rule, a law, and just a policy. And so much of what the Department of Health and Human Service does is policy. They promote it out there, and it's not factual. So I'm sending that message home. You need a rule. And I can give you several examples. I think, honestly, while it may be a good program, RAMS is one of those. I don't think it's been through any kind of rulemaking process. Another one is, and I don't have any more judges in here, I used to, but it used to be that they would do these safety placement agreements, and there was no statutory authority for it. So then they came up and decided, well, we might get sued because we've left children out there too long. So they modified it and said, if you do a safety placement agreement, then you have to put it in court within 30 days or within 60 days. Courts went a little crazy over that. I asked, where did you get the authority to do that? Well, we didn't have the authority to do safety placement agreements, so we didn't figure we need authority to fix it. That is an example of you need to have a rule. You need to make sure your rules comply with statute. That's what we have a whole rules review commission for. So I'm hoping that answers your question.
May I respond, Mr. Chair?
Follow up.
It does. And I guess my thought would be that if those things were to occur and the agency or its designee acted without requisite authority, that would in and of itself be some type of violation, whether willful or negligent, and they could pursue remedy through the Tort Claims Act. My real concern is that this private cause of action, I think it's unprecedented when it comes to piercing governmental immunity generally, and that's a little bit of a concern. I think a lot of times our state employees, especially within HHS, they have discretion, this discretion exercising function, I think is what case law would call it, and you don't want to paralyze those employees when they're having to make tough decisions when time may be of the essence. and expose them to litigation because of it. And so this is more of a general concern I would highlight.
All right, I'm looking at the clock on the wall, and we have a number of people signed up to speak, but I don't know that we're going to have time before our allotted committee time for them to speak. So at this time, if there is a motion, I will entertain that.
Mr. Chair, I just want to say that I'm happy to meet with anyone who has concerns as it goes to health. Happy to talk with you.
Do I have a motion?
Thank you, Mr. Chair. I'll make a motion.
Representative Purtle, you're recognized for a motion.
I'll make a motion favorable to the PCS, unfavorable to the original, referral to health.
All right, we have a motion for a favorable report to the PCS of House Bill 237, unfavorable to the original, with a referral to health. All those in favor signify by saying aye.
Aye.
All opposed, no. In the opinion of the chair, the ayes have it. The ayes do have it, and it'll be referred favorably to the Health Committee. So any of those folks that were signed up to speak on the bill here, we didn't get to, keep checking the Health Committee schedule, and maybe you can get that opportunity there.
All right, thank you. We are adjourned.